Hey everyone, I hope you're doing well and staying safe during this time. If you're new here, welcome to the channel. Like I said, thank you so much for checking me out. If you haven't done so, please make sure to hit that subscribe button just right below the video. Cool, thank you so much. I really do appreciate it. And if you're returning, welcome back. Thanks again for your support. I truly do appreciate having you here.
Yesterday's news was absolutely huge. I mean, hell, that's an understatement. It's impossible to overstate how big of a deal it is that yesterday Judge Torres announced the finding that Ripple will be allowed to argue their fair notice defense. But you can't win them all. The court has rejected Ripple executives' case dismissal, so that would be for Brad Garlinghouse and Chris Larson. And the court found, this was kind of surprising me based on all the information that has been made publicly available to this point, but the judge found that the XRP sales by Brad and Chris were actually not predominantly foreign. And that's an important thing to point out because the SEC doesn't have any sort of jurisdiction over transactions that occur outside of the United States. So anyway, I'm going to share with you the specifics of this. I also got a couple comments from individuals like Ripple CEO Brad Garlinghouse, and he did briefly mention this. And also Stuart Alderati, who is the general counsel at Ripple, so he's their top in-house legal guy. Plenty to discuss, but before going further, I just want to be clear, I do not have a financial background of any kind. I am not offering financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto topics, but just as a hobby and just for fun. The same day the SEC vs. Ripple case saw the judge denying the SEC's motion to strike Ripple's fair notice defense, Magistrate Annalisa Torres also denied Chris Larson and Brad Garlinghouse's motion to dismiss the SEC's complaint against them. The court denied the individual defendant's request because it assumes the SEC has adequately alleged the existence of a securities law violation. And so, to be clear, and hopefully this is obvious, but we're saying this is not some sort of acknowledgement that what the SEC is alleging is accurate. All that's being alleged at this point is that all that's being acknowledged here by the judge, basically, at this point, is that the SEC has sufficiently alleged the claim up to whatever the legal standard is to allege such a thing. And that's actually most of what this legal complaint is. I can hear a paper. I printed up this bad boy. It was 31 pages, and I'm not going to read much from it, frankly, because first of all, the first 12 pages was just background information, which is not necessary for the purpose of this video. And then a lot of it is just going through case law, setting the table as to why all this, why the SEC did adequately make their claims, and it's a bit dry, so I thought I'd just kind of get the big points, and then we can just move on from this. But anyway, piece continues. Still, the SEC must show the individual defendants joined the specific venture and shared in it, and that their efforts contributed to success. The SEC also must show their general awareness of their overall role in Ripple's illegal scheme, said the judge, who further explained, quote, notably, the SEC need not demonstrate that the individual defendants were aware that Ripple's scheme was illegal. Rather, the SEC must show that the individual defendants knew or recklessly disregarded the facts that made Ripple's scheme illegal. And so, I do want to read this one part before going any further, and then I want to jump into the part that I found to be most interesting, which was that the judge found that Brad and Chris's sales not predominantly foreign, meaning that the sales constituted transactions within the United States and to United States citizens. Based on what I had known to this point, that seemed like an unlikely find, but that's what the judge has reported here. But take a look at this. Regarding the application of law here, this is a high bar. So check out what the SEC must do. This is what the judge wrote. To hold a defendant liable as an aider and abettor in a civil enforcement action, the SEC must plead and ultimately prove, number one, the existence of a securities law violation by the primary as opposed to the aiding and abetting party, and two, knowledge of this violation on the part of the aider and abettor. So, folks, that's a higher burden of proof than you'd have, than the SEC would have to meet had they not charged the executives, which is what I've been saying for a long time. The first the individual I saw, our lawyer within our community that I saw bring this point up, I think was John Deaton, probably like over a year ago. The fact that they charged Brad Garlinghouse and Chris Larson, this is unprecedented. The fact that they charge in a non-fraud case, this just doesn't happen. But it's going to make the SEC's job that much harder. They have to prove a lot more things than they otherwise would, including again knowledge. How was it worded? Knowledge of this violation on the part of the aider and abettor. So, here's the reason it matters. If there's not sufficient legal clarity surrounding XRP and the fair notice defense is clearly in play, you can see how this would make it a lot more difficult. Because, frankly, the SEC didn't even know that XRP was a security until December of 2020. That's when they decided it, publicly announced it by suing Ripple. So how the hell was Brad Garlinghouse and Chris Larson supposed to know that what they were doing was wrong? So this is all in play now, especially thanks to this huge win yesterday regarding the fair notice defense. And then number three, substantial assistance by the aider and abettor in the achievement of the primary violation. So really, point number two is the one that's going to be hardest out of those three in my estimation here. Now we have this little subheading, XRP offers and sales not predominantly foreign. Judge Annalisa Torres also dismissed the argument that XRP sales were predominantly foreign, as the court found Larson's and Garlinghouse's offers and sales were made by United States residents. And here's a quote. The Second Circuit has held that the presence of a domestic securities transaction is a necessary but not sufficient predicate for invocation of U.S. securities law, and when transactions involve wholly foreign activity, clearly subject to regulation by foreign authorities, the Second Circuit has found securities law violations to be predominantly foreign and, therefore, outside of the territorial scope of United States securities law. So pause. That's why I was expecting this to maybe be a little bit more likely to go in the favor of Brad and Chris. This specific topic, at least, I wasn't sure whether or not the case was going to get thrown out. I was kind of neutral on that. I just wasn't sure what to expect. But on this particular point, kind of surprised to see this. And again, the reason being that the argument had been made, apparently not accurately, according to the judge, that the vast majority of these transactions, if not all, took place outside of the United States, which means that like I said earlier, that the SEC would not have any sort of jurisdiction over this anyway, and then this piece continues. In the two cases where the Second Circuit determined that violations were predominantly foreign, the conduct occurred in a foreign country and concerned securities in a foreign company that were traded entirely on foreign exchanges. And so here's the most important part. Here, the court finds that the individual defendants' offers and sales were not predominantly foreign. These offers and sales were made by United States residents, involved alleged securities issued by a United States company concerned at least some offers and sales made on United States-based platforms and included at least some offers and sales made to United States purchasers. Thus, the application of Section 5 to these offers and sales would enhance confidence in United States securities markets and protect U.S. investors. So look, it appears that even if it were just a handful, based on what I'm reading here, even if there's just a handful of transactions that occurred in the United States, apparently that still would have been enough for the SEC to claim, hey, violation. It's totally plausible reasonable to bring this case against them. And then they wrap up the piece by stating, while Chris Larson and Brad Garlinghouse lost their separate motion, Ripple has scored a major win. The fair notice defense was allowed by Judge Torres, who denied the SEC's motion to strike, and that's obviously gigantic. Talk about a reason to jump for joy. In fact, here's a tweet from Stuart Alderati, who again is Ripple's general counsel, so he's their top lawyer, and he tweeted out the following. Today's order makes it clear there's a serious question whether the SEC ever provided Ripple with fair notice that its distributions of XRP since 2013 would ever be prohibited under the securities law. Good to see the judge rejecting the SEC's attempt to prevent Ripple from pursuing its fair notice defense. It's even more imperative that the sun sets on the SEC's regulation by enforcement approach. Amen to that, my friend. And then Brad Garlinghouse, Ripple CEO, retweeted that and wrote the following. If you weren't paying attention then, you should be now. Huge win for Ripple today. And while we would have preferred the cases against Chris and me to end now, the SEC must now prove its claims. We are confident that ultimately all of them will be dismissed. And again, like I said, higher burden of proof now because you charged Brad and Chris. SEC just made the job a lot harder for yourselves, but okay. Getting a little overzealous there. And then there was this Eleanor Terrett, who is with Fox Business. She's a journalist over there. She got a comment from Stuart Alderati, so this is a separate comment from what I just read to you, which he shared on Twitter just a moment ago. Here is what Stuart Alderati stated to Eleanor Terrett, and reads as follows. Today's order confirms that there is a serious question as to whether the SEC ever provided Ripple with fair notice that its distributions of XRP since 2013 would ever be prohibited under the securities laws. We will continue to fight hard in defending this case so that the industry can get the needed clarity it deserves to move forward and thrive. And while we would have preferred the cases against Brad and Chris to end now, the court has decided to make the SEC prove its claims. We are confident that ultimately all of the SEC's claims will be dismissed. Yeah, looking forward to it. And then there was this. I thought I'd wrap up the video with this. This is just funny. If you can look at your screen, do so now. You guys familiar with the 90s video game Mortal Kombat? This is Mortal Kombat 2 right here. I remember being a young lad playing this game. I used to love that game. And you're just gonna have to look. It's the finishing part where you defeat your opponent and you can do a finishing move, and it's just got one of the characters from the game with Gary Gensler's face about to be finished. He's got a little SEC logo right here where I'm circling. So anyway, I thought it was pretty funny, and I thought I'd just share it with you. So there we go, finish him. Well, we're about at that phase, aren't we? But truthfully, though, I still think more likely than not we're going to see settlement. In fact, I feel highly confident that settlement is the most likely outcome here. And I could be wrong, but at this point I think it's the most likely outcome now that the SEC's really got something to lose here. Because I'm telling you, if precedent is set,
I'm your guy. I will keep you posted. I'm your advocate. I'll be back on a daily basis, usually multiple times per day, with these videos to keep you updated with everything going on. So I hope you enjoyed the video. If you haven't done so, make sure to hit that subscribe button. Feel free to share any of my videos with your friends, family, social media, or anybody who may care to listen. Thanks so much for your continued support. I'm always here for you. I want to help you through this time. So thank you so much for continuing to choose me. Enjoy your day, stay safe, and I'll catch you again probably in a couple hours. Thanks, everybody. See you later.